overturned. So this type of lawyering, I believe, is good for the prosecution, especially in a case where you have the evidence you need to prove the case, right? If you don't have the evidence to prove the case, you shouldn't be bringing it anyway, right? As a prosecutor, I say we because I used to be a prosecutor, are only supposed to bring cases that, number one, we believe in and we believe we have the evidence to prove beyond a reasonable doubt. If we don't believe it, then we should not be bringing the case. Let's bring in our think tank. Joining us tonight in Cleveland, Ohio, retired judge, former prosecutor in Cuyahoga County, and judicial fellow at the National Judicial College, Judge Gail Byers is with us. Also joining us down in West Palm Beach, Florida, nice and warm there, trial attorney, former police lieutenant, great attorney, Rick King. And in Los Angeles, deputy public defender for LA County, always fighting the good fight, Philip Dubé is with us, and he's always reading up on all these cases and tries to throw that Constitution at me every week, Philip Dubé does. And that's why we need lawyers like him, right? That's why we need him. All right, Judge, any shock here, any surprise? And is my analysis on point here that this is going to be one of those cases where you've got a defense team dug in and they're going to fight everything, the judge is going to have to work hard, and prosecutors are going to have to work even harder?
Well, Vinnie, here's what I'll say is you must have been one heck of a prosecutor, because you hit the nail on the head on all of those important points, starting with the purpose and the charge to the grand jury. I used to be the supervisor of the grand jury here in the largest county in Ohio, and you're absolutely right. You shouldn't bring cases that you can't win with a petit jury, which is the jury you commonly see in the courtroom. But that standard of proof is way below beyond a reasonable doubt once you've presented it to a grand jury. And so, no, I'm not surprised. But I think you're right that the judge can't possibly fall asleep in the middle of this trial, because they're going to have a dogged defense team that's fighting them tooth and nail, as they should, to ensure that at the end of the day that the defendant's gotten a fair trial. And, hopefully they come away with it, although there seems to be a bit of evidence, or quite a bit of evidence, that points in the other direction.
Rick, something that I noticed when I was in the prosecutor's office, like the attorneys that would have that approach to every case, that are going to file the motions, fight, not give an inch. In lesser cases, not a case like this, but in lesser cases, they get the deals, right? Prosecutor's like, all right, just give him the probation, just give it to him, so we don't, right? That's the way our system is kept honest.
So, for the most part, you're right. I will say this, I'm going to push back a little on this, that prosecutors only bring cases that they believe in or that they think have all the evidence, because I think Mr. Dubé would agree with me that sometimes cases come toward us where we're like, come on, you don't have anything here, but they still bring them anyway. So with that being said, my former law partner used to always say this. He used to say that lawyering is one of the few jobs where you have an equally skilled adversary on the other side, forementing and trying to push back on every single move you make. And that's what I expect to take place in this trial. You're going to have the defense lawyers filing motions and trying to zealously advocate for their client, and you're going to have the prosecution fighting those motions and equally bringing their case with zeal. And I think that's what you're going to see here.
Philip Dubé, this is what you've made your career doing, right? Being a real pain.
Of course.
What a pain, right? For the prosecution. Oh, man, Dubé's got the case. Just give him a deal. Get him out of our hair.
You know, I really hate to say it, but we have a constitutional duty to defend. And if that's going to be denominated to be, labeled a pain, then so be it. It is what it is. Because frankly, if and when Bryan Kohberger is convicted of all of these homicides and sentenced to death by an Idaho jury, the first thing that appellate counsel is going to do is go through the entire record from the trial below and even the pretrial proceedings to see if counsel was ineffective in any way. They're going to look for every procedural and substantive avenue to attack the performance of trial counsel. One of the motions, I don't know if it's still pending, if it was already denied, I truly felt lacked merit, and there was a disagreement among members of the defense bar, and that was the motion to dismiss the entire prosecution on due process grounds for failure to preserve the house where this massacre occurred. There is this line of cases, the Youngblood, Trombetta line of cases that says that when law enforcement fails to preserve evidence that's exculpatory, it could be grounds for a complete dismissal on due process grounds, but only if the failure to preserve was done in bad faith, meaning out of some kind of animus for the defendant. That's clearly not the case here. I understand why the issue would be raised, but if we really think about it, is that house really exculpatory? Or
Well,
is it
let's
just
talk
sort of
about let's talk
collateral to
about the
issues?
house, because right now that house is still in existence. It's boarded up.
Yeah.
But is scheduled for demolition 3 days after Christmas. Take a look here. This is a note from the University of Idaho president, Scott Green. They own the house now. The owner just gave it to the university. It is the grim reminder of the heinous act that took place there. While we appreciate the emotional connection some family members of the victims may have to this house, it is time for its removal and allow the collective healing of our community to continue. And I don't know, I was a little offended by that, saying that we appreciate that some family members may have some. I think the families have been a little bit more impacted by what happened here than the community at large at the University of Idaho. By the way, the house is actually off campus. It's not on the campus of the university, but the university does own it now. So here is a note that was posted by the Gonzalez family on their page. So I've really been having a hard days this week. Today was especially hard because we were notified that they plan on tearing down the house on December 28th, just 3 days after Christmas. Here's the thing with the house. I get it. It's an eyesore. It makes the community and college sad. It's a house of horrors, so on and so forth. Yes, Kaylee, their daughter, unfortunately died in that house, but more importantly, Kaylee lived a fun, happy life in that house. So my point is, when the house is torn down, it will be a very sad day for me. Salt in a wound that never heals. Meanwhile, there is now a petition to halt demolition until after the trial. And there was a comment on this petition which is allegedly from Xana Kernodle's mother, that said, my daughter was murdered in that house and there's no way they should be destroying any evidence. All right, so Rick, what are your thoughts on the house?
So I think that they should preserve the house until the trial is over, because it's a murder trial and you never know what's going to come up and you never know exactly what you may need to test against the evidence that we already have. And if you tear the house down, it's gone. And, you know, as a defense lawyer, I'm remiss to not say that, hey, that's part of the evidence. And if I have something and you don't preserve it, believe me, that's going to come back and bite the prosecutors in the butt. I think that the prosecutors should be arguing to keep the house until this case is resolved.
Yeah, I think they should go in and get a court order to do it. But it seems both sides, no problem with it being torn down. I get it. It's a small town. It's tough for the kids. But, you know, this case is not over. This case is not over. Philip Dubé, I think we heard a little bit from you about this. I'll go to the judge first. Judge, what are your thoughts about the house? And are you shocked that prosecutors are okay with it being knocked down and prosecutors don't want to walk the jury through the house?
Well, I say, Vinnie, is concerning. And here's why, is there's no substitute for what we call the best evidence. And the best evidence rule, although, you know, there's evidence that can often substitute one for another, in this instance, if you wanted to perform a jury view, or if you wanted to give your jurors, you know, the bird's eye view, if you will, of the actual crime scene, then the best evidence is the house itself. And even though there may be a digitized replication of the house, that is not a substitute for the actual structure. And what's more is the prosecution, by not requesting the very injunction you just mentioned, is perhaps providing the defense with the biggest gift that they possibly can, because to Mr. King's point, you never know what's going to happen in a trial. If something comes up, there's no better way to test it than with the actual evidence itself. And with that gone, it really hamstrings them to be able to do that.
Philip Dubé, I've covered many cases up in Massachusetts, and it's very normal in Massachusetts. Before the trial even starts, before opening statements, the jury, when applicable, right, does a view of the scene of the crime. To me, it comes down to this. A trial, as we always say, is a search for the truth. Anything that can help the jury get there, I think, is important. And it's amazing, as a journalist, going on these views before the trial gives me a much different perspective of the evidence that you see inside the courtroom. Like, it makes more sense, and it makes me think, and it gets me closer to understanding what really happened. I don't understand why on earth anyone would want this house knocked down, and why anyone associated with the trial wouldn't want the jury to walk through there.
I cannot tell you how many burglaries and homicides I've tried where there have been 0 jury viewings. 0. I cannot tell you how frequently all of these cases are tried based on documentary and digital evidence. The bottom line is that the purpose of a jury viewing is to assist the trier of fact in analyzing the evidence. I think at this point it is purely speculative to say that the 4 walls within each room are going to exonerate Bryan Kohberger. Unless you can point to something to show a compelling need to preserve that house, I think right now you're just kind of, spitballing the idea that it may have some value in the future. But the truth be told, jury viewings are more the exception than the rule for a few reasons. Number one, they're expensive, okay? And number two, they really don't add much, if we're honest, What
no.
What are they going to add?
Oh, wait.
What is it going to add?
It's going to add a lot. Number one, to walk the grounds, someone had to break into that house. How do you get in? How do you get out? How close is the house to the other houses? When you walk, it's so different. It is so different. When I was covering the Murdoch trial from here, and then went down there and went to the property, what a different perspective I had on what could have or could not have happened that night. Okay. Same thing here. When I walked the staircase that Michael Peterson's wife, Kathleen, was bludgeoned to death on, I walked that staircase, I saw that blood spatter, I was like, there's no way this was a slip and fall. No way, something terrible happened in there. And the jury went there as well. So I don't know. Call me crazy. I like the jury to get to the truth, Rick King.
I don't even let's forget the whole jury view thing, because he's right that burglaries, murders happen all the time, but there's not a jury view here in Florida. Here's the thing though, and this is where I think that you really have to consider it in the sense that as a defense lawyer, if the defense brings something up, an angle or an area of the room or something where we're alleging that something may have happened, and all you have is the digitized version of the picture, it might not be enough. I just think for the mere instance that the defense might come up with something that we can test against the actual structure, I think for that reason alone, we maintain it.
And what you're seeing right now in this show, right? Top row versus bottom row, what you're seeing is really important, an important lesson here. I'm concerned with, as is the judge, the jury getting the truth, right? Getting to the truth of what happened and give them the information. On the bottom, representing the defense bar, I'm not criticizing, I'm just pointing out the reality. Well, could it help the defense? Could it help the defendant? Whereas we are concerned about just getting the jury to the truth of what happened, whatever it is, and the bottom row, defense attorneys talking about, is it good for the defense, right? That's the difference.
Or maybe help the defendant prove that he's innocent.
Right. Yeah. But if it doesn't help the defendant, you don't want him there. Either way, I want him there. That's just me. All right. I want